purpose of money laundering as a statute is to prevent folks from taking illegal proceeds and running them into the formal banking system such that they look like they are legitimate funds. There are a couple different ways you can run into trouble with money laundering. The first is called promotional money laundering. The best way to think of this is promotional money laundering are like bookends. You have proceeds from illegal activity, illegal funds, and then you have on the other end, they're being distributed to promote ongoing criminal enterprise. And what happens in the middle is money laundering. Honestly, this could be as simple as if you take money from an illegal business and you put it in your bank account, and then you take it out of your bank account or use that bank account to pay for some aspect of the business. This one can be a little tricky, especially where, the courts are going to be reluctant to criminalize something that someone could happen into accidentally. Promotional money laundering is also, I think, harder from a prosecutorial perspective because, like I said, the bookends. You have to prove it's illegal coming in and that the person who is being charged knew that and that it is illegal going out. Fundamentally, keep in mind that the act of money laundering is some sort of financial transaction. It could be a mobile banking app. It could be depositing something. It could be really anything. And it's, again, pretty broad that would constitute a financial transaction. The other big type is called concealment money laundering. More or less exactly what it sounds like. It's money laundering, so there's got to be a financial transaction. Is this financial transaction intended to hide the unlawful origin of this money? The most common example that I ever saw is something called layering. It's where someone will just move money through various accounts. You steal money, you deposit it in one bank account, you move it to another bank account, you move it to another bank account. That can slow investigators down, but typically it won't stop them because everything leaves a paper trail except cash. And so what can happen is you'll see someone think that they are successfully removing themselves or distancing themselves from the unlawful origins of the funds. And really what they've done is they've walked right into a money laundering charge. Some details about concealment money laundering. The first big SJC case, Commonwealth v. Braun. The Supreme Judicial Court of Massachusetts said when there are what they call cognate provisions, which is a fancy legal term for you copy pasted it from federal law, they say you can look to federal law as highly persuasive in how you should interpret it. What that means is that prosecutors will look at federal law to see how have the courts treated this application of the law in the past. The other point about concealment money laundering is that it has to be an animating purpose of the transaction. So if you are doing banking transactions with illegal proceeds, but the concealment is sort of like incidental, then there's a good defense that you weren't doing specifically this kind of money laundering. There are other types that have to do with something called structuring, where you're depositing money in small enough amounts in the hopes that no one will notice. That can run afoul of reporting requirements, or it can make it look like you're trying to avoid triggering reporting requirements. That's a bit more hyper-technical than I think I want to get into in this video, but it's just worth knowing that it's out there.